Sarah, if you wanted to say hi on behalf of OUP.
Okay, hi, I'm Sarah Harris, the Managing Editor of the Journal of IP Law and Practice, and welcome to our fourth webinar. Today, Stefano Barazza will chair a discussion around UK patent law. We're actually benefiting from a preview today, as the roundup article accompanying this webinar hasn't yet been published. We'll alert you as soon as it's out. We're again very honoured to be joined by an expert panel of speakers. Before I hand over to Stefano to introduce everyone, I'd like to encourage those watching who might be contemplating a lockdown writing project to consider contributing to the journal. We're always delighted to receive submissions, and all the details are on the website. Thank you very much to our speakers and to Stefano.
Thank you, Sarah. Thank you very much. And thank you everyone for joining today. There's now 64 participants. There's 180 registered, so I think other people will show up in time. We are currently missing one of the speakers, but we hope that he will join in time, and otherwise Trevor has volunteered to pick up Ed's part. So as Sarah said, for those of you who are not familiar with the roundups, we used to run as a journal a single roundup of decisions every year, focused on trademark law. And this year we have decided to expand this series of roundups, and we've had roundups on national and CJU copyright decisions, roundups on enforcement decisions, and 4 roundups concerning specifically patent law. And Trevor has been fantastic, and I need to thank him right from the start for putting together a team at WilmerHale that has provided roundups concerning not just UK patent decisions, but also US decisions, German decisions, and Chinese decisions. And all these 4 roundups are now all edited and going through production at OUP. They should be published very soon, and OUP will make them freely accessible to everyone. So we were hoping to have at least the UK patents roundup already available for everyone today. We haven't managed to do this, but it will be available very, very soon. And we will post details on the blog as soon as that is available. Okay, so
Ed has joined us.
Ed has joined us, fantastic.
I'm so sorry I'm late. Somebody was very worried about an injunction and decided to give me a phone call.
No worries, we made all sorts of jokes about barristers in the meanwhile, but other than that, we're very happy that you've joined us today. So let me, without further ado, introduce our panel. You have, of course, already seen Trevor, who is, I'm sure, familiar to all of you. He has been working in the field of patent law for 40 years.
Yes.
He doesn't demonstrate that, so you would never say it, but just looking at him, but he has indeed been working in this field for very long. He's the author of several books and articles in the field of IP, and mostly focusing on patent law as well. He's a partner at WilmerHale, and as I said, he doesn't need probably any other introduction because it's so familiar to all of you. We're also very fortunate to have Kit Carter, who's joining us today, and she's second in my list of speakers on Zoom. Kit has just joined the London team at WilmerHale as a senior associate. She is an immunologist by training, right, and still extremely interested in that field. And as I discovered today, and as I was sharing with her earlier today, also a keen photographer that I discovered participates to lawyer photographers competitions. That was absolutely impressive. And our third speaker has just joined us, Edward Cronan, former solicitor and now a barrister at Hogarth Chambers. He has been working across, I would say, all the domains of patent law now, with some specific interest that we will get a peek of today, including front. Edward also has a very interesting blog, which I wanted to mention, cronan.co.uk, because for many of our participants who are interested in keeping an eye on what is happening in the field of patent law, I know that you publish some sort of review essentially every month when you can about patent decisions, and I found them always very interesting, and I keep an eye on them when they come up. So I just wanted to share this with our participants today as well. So we have about 1 hour today, and we have already taken 6 minutes of that 1 hour with lots of things to discuss. We started with this idea that in patent law in the UK, this has been a quiet year, and Trevor very rightly pointed out that no major changes have happened. But in fleshing out the details of what has been happening in this year, I think we have found a lot of very interesting things to discuss. And so Trevor, Kip, and Ed will have a lot to discuss today. Before handing over to them, just three essentially housekeeping items. I'm going to share with everyone in the chat a document that lists all the webinars that we have already had with links to their YouTube recordings, and also links to the future webinars, including 2 webinars on patent law that are coming in the next couple of weeks, just for any of you who wants to sign up for them, and as a bit of a reminder for everyone. Of course, we're going to also we are recording this webinar as well. It will be put on YouTube and it will be available for everyone, which is also one of the reasons why we're asking you to keep your microphone muted and your camera switched off, so that we can then make available this recording without issues on YouTube. Second housekeeping item, I'm also going to share right now in the chat a list, essentially a slide set for this webinar, which is inspired and follows the structure of Trevor's article and Trevor's roundup of UK patent litigation. And we've put together these slides, but we're not going to project them as the speakers speak, simply because that would reduce the speakers to a tiny picture on Zoom. So we thought that it makes more sense for you to have the slides. You can refer to them as the webinar goes on, but at least we're not taking up the entire screen on Zoom. The slides also contains all the links to all the cases that we're going to discuss today, and so they could be useful, not just to follow the seminar right now, but also later on. A final point before handing over to Trevor. If you have any technical issues, you can use the chat to share them with me, and I'll try and sort them out as much as I can on Zoom. If you have any thoughts, reflections, and questions on what is being discussed in the webinar as well, please use the chat to share those thoughts. I'm not sure that we will have time at the end to stay within the hour to discuss also questions, but I will keep an eye on the chat, and if there's a selection of questions that we can address at the end, we will do so. As Sarah said at the beginning, if we don't have that time, of course, questions are the perfect topic for articles, and so we will encourage you at the very least to write on the questions that come up in this webinar. Without further ado, Trevor, I hand it over to you to give an overview of what we're going to discuss, and then starting from, I think, statistics.
That's right. Thanks, Stefano. Thanks, Sarah. Starting on slide 3 of the presentation, which has been shared, that sets out an outline of what we're going to talk about. Rather than just go case by case, we're going to go through topics, starting with infringement, equivalence, then a number of validity issues, procedure, remedies, then some specific topics such as employee compensation, where there has been new law, and then a little bit of speculation for the future. But as Stefano said, it's not been a year of great change in UK law, but there has been a lot of useful restatement of the law, filling in of detail, and so from that point of view, it's an interesting year to review. If we move on to the statistics, which are on slide 4, we can see there were 16 final decisions in which validity and infringement were an issue, involving 19 patents. And 4 out of those 18 patents were held valid, which I think is probably a pretty traditional statistic in the UK. As we know, the UK tends to attract challenges to patents either on validity grounds, perhaps before other countries, because of the speed of its procedures. But what I do want to flag up there, and I'll be talking about in rather more detail, is the fact that in none of those cases was a patent held not infringed. In some cases, infringement just wasn't an issue, but in all the other cases, patents were held infringed in some of those cases, in several of those cases, solely by reason of the doctrine of equivalence. So I'll be talking more about that. There wasn't so much action in the Court of Appeal, 3 appeals, and the judgments of first instance were upheld in every case, with 4 out of the 5 patents being valid, 1 obvious, and none were held to be not infringed. So from that point, going on from there to the question of infringement and equivalence on slide 5. I mean, this is really, if you like, I think one of the big take-home messages of last year. Not a single patent was found not infringed. And we, of course, know the background to that. The UK Supreme Court decision in Eli Lilly v. Octavis back in 2017, which said that the existing approach to determining equivalence was unsatisfactory, and that there was in effect a 2-stage process. The first stage of actually construing the claim, and the second stage of then applying the doctrine of equivalence to it. And to achieve that, what the court did was it sort of transplanted from the construction stage, from the construction phase, this 3-step test, the old improver questions, into the equivalence analysis. And by changing the context in which those questions were addressed, has made a radical change to the law. And we're starting to see that work through in the case law. Yeah, perhaps the reasoning in Eli Lilly and Octavis itself is maybe rather fairly heavy going. So, I mean, I would certainly commend the analysis in Icescape and Iceworld of Sir David Kitching in the Court of Appeal. And that's also interesting because I often feel you can't really get your hands around the doctrine of equivalence and see its significance until you're dealing with it in the context of mechanical patents. And Icescape and Iceworld was such a thing. And you see the real potential breadth of the principle in that case, where certain features of the claim were disregarded because they were not part of the inventive concept. So it didn't matter that those features of the claim were actually fulfilled. I've talked about the statistics for last year. Although in 5 of the cases there was infringement solely by reason of the doctrine of equivalence, it only actually affected the total outcome of 2 cases, because in the other 3 cases the patents were found to be invalid anyway. But I'd like to flag up 2 cases in particular, which I think are very significant going forward. One is the Regan and Estar case, and that concerns the effect of numerical limits in claims. Under the old English case law, before Eli Lilly and Octavis, it was fairly clear under the 3rd improver question that if somebody had inserted a numerical limit in the claim, that meant something, and you had to apply that numerical limit, and that it was, if you like, what the patentee had actually intended. You had to respect that. And so there were a number of cases where people sort of said, well, what's the numerical limit? You analyze that in terms of significant figures or whatever. There's quite a lot of case law around that. Now we can just forget about all of that on the basis of the Regan and Estar case, because the trouble with transplanting the improver questions from the construction phase of the analysis to the equivalence phase of the analysis is in the context of equivalence. You know, what does really a numerical limit mean? You know, once you've decided that the accused accused product or process involved the same inventive concept, then are you going to be interested in, you're going to think fine details in terms of numerical limits in claims matter? Well, certainly in the Regan and Estar case, they were disregarded. And that's a case which would have gone the other way under the old The other case I wanted to flag up is the Formstein defense, is one which starts to import the Formstein defense from Germany, Technetics and Teles. That was a case in IPEC. There's a long discussion, and the issue here is once you start broadening out the scope of protection by means of the doctrine of equivalence, you start covering either the prior art or obvious modifications of prior art. How do you then deal with that? And the Germans have for long had the Formstein defense, which would address that. In the US, they have the doctrine of ensnarement. These are quite fully discussed in the Technetics case. And so in that case, without coming to the conclusion that there was actually a Formstein defense in UK law, because he didn't have to go that far because he found the patent invalid anyway, the judge held that although the patent was infringed on the doctrine of equivalence, the Formstein defense would have applied to effectively preclude that finding, or at least determine on that interpretation. It wasn't clear quite how he framed it, that the patent would have been obvious on that interpretation. So we're going to see more application of that going forward in other cases. This is it's been touched on in previous cases, but this is the furthest development of it so far. Just before I leave infringement of the doctrine of equivalence, let me say it is still possible in English law not to infringe a patent. We had a case, and I'm cheating by jumping out of 2019 and into 2020, the Acabia case, in which an argument that two different chemical molecules, which it was asserted had a common structural motif. One was specifically disclosed in the specification, another was not. It was not part of the Marcuse claim. An argument that there was a common structural motif, which, if you like, constituted the inventive concept for the first stage of the application of the improver type questions. It was held that there was no common structural motif there. So the attempt to stretch the doctrine of equivalence into chemical similarity failed in that case, but not necessarily as a matter of principle. It's something we still see being pushed forward going forward in the future. So watch that space, but with that, I shall hand over to Kit.
Thank you, Trevor. So we're going to move on now to the first of our topics under validity, and that is the topic of anticipation, and in particular the question of enablement in the prior art. So this was considered in the case on the slide, Takeda and Roche. And this is a case that will come up at least a couple of times in this presentation under obviousness and insufficiency. It's one of those cases that has a bit of everything. And we've got so many cases in this presentation, I don't want to go into the facts in too much detail, even though they relate to my favorite thing, which is monoclonal antibodies. But I will say that the critical feature of claim 1 of this antibody patent belonging to Roche is important for us to just take note of, because it comes up into the analysis, which is the requirement for an antibody to exhibit at least 99% fucosylation, which is just adding sugar groups onto an antibody, essentially. So Takeda brought a claim for revocation to clear the way for its monoclonal antibody product, and we're going to look at the novelty attack based on anticipation in the prior art. So, as we all know, an invention is not new if it forms part of the state of the art. You get that from Article 54 of the EPC. And in the House of Lords, as it then was in Synthon and SmithKline-Beecham in 2006, to lack novelty over the prior art, there are two requirements. and those are those of disclosure and enablement. So a product is enabled if the skilled person can reproduce it without undue burden, and that might be from obtaining a sample and reverse engineering it, or following the teaching in a prior art document. And the dispute here between Takeda and Roche focused on what exactly has to be enabled. Is it necessary, as Roche maintained, that the skilled person should be able to reproduce exactly what was disclosed in the prior art? Or is it sufficient, as Takeda argued, that even if the skilled person that the skilled person should be able to reproduce something falling within the scope of the claim, even if it differs from the prior art in some features? And Mr. Justice Burse agreed with Takeda that it doesn't matter if the skilled person's creation would not reproduce exactly the product or process described in the prior art. It's enough if they produce something that falls within the scope of the claim. And one interesting thing about reaching this decision is that in doing so, Mr. Justice Burse considered a number of EPO authorities concerning antibodies, which on their face looked very strong in favour of the argument that you had to reproduce exactly what was in the prior art. And these were T2045 of 09 and T1833 of 14. Mr. Justice Burse disagreed with that analysis of antibodies. He said that it just doesn't make sense, particularly when it comes to antibody claims. Antibodies are, by definition, a population of molecules, and there will inevitably be a degree of variation between molecules in a population. So you cannot sensibly look at a prior art disclosure and say that there is some minor, a different feature in the prior art disclosure that would render essentially every patent claim to an antibody novel. This is another example which will probably come up again when it comes to added matter, where we have the UK courts deciding that the EPO takes a rather strict and rigid approach to things, where our courts tend to favour something a little bit more, I don't know, practical, shall we say. So applying this reasoning in the case, the judge found that each of the pieces of prior art pleaded were an anticipating disclosure, and they were enabled. The skilled team would be able to make something that fell within the claim, and that was enough to render the patent invalid under this ground of invalidity. So I think I'm going to hand over now to Ed to talk about obviousness.
Thanks very much. So as we've heard from Trevor, inventive step has been the leading route to patent revocation in 2019. And we've also had the benefit of the Supreme Court's wisdom in the Actavis and ICOS judgment given by Lord Hodge. Now, many practitioners were very relieved to see the Supreme Court decided not to take the opportunity to shake up the law as they'd done with equivalence, lest they risk the ire of Mr. Cook for messing with his patent law too much. And you don't have to take my word for it. You have the word of Mr. Justice Arnold in the case of Allergan and Aspire. And he noted specifically that the effect of the judgment was to confirm the approach which had previously been adopted to this question. Namely, that the trial judge has the discretion to decide the point as they wish, using a sort of a long laundry list of factors which the Court of Appeal won't be particularly tempted to interfere with. Now, the case itself related to a dosage regime for the drug tadalafil, which, as we all know, is a phosphodiesterase type 5 inhibitor, which indirectly promotes the release of cyclic guanosine monophosphate, which leads to the relaxation of smooth muscle, blood flow to the corpus cavernosum, which gives the patient an erection. Now, this was the second-in-class drug to Viagra. And the reason this is relevant is because it explains why there was such a big dispute. Because dosage regimes with this kind of drug are particularly important, particularly given that the regime in this case was 5 milligrams daily chronic dosing, rather than what was called on-demand dosing. And you can see that, that it's a much more valuable proposition to be able to say you can have a once a day, just in case measure than a use it when you need it kind of measure. And the Supreme Court decided that this wasn't inventive. They disagreed with Justice Burt at first instance, upheld the judgment of the Court of Appeal, saying that there was a logical consequence of the work that would be done in dose ranging. So it couldn't be an invention, because any normal dose ranging study, based on what the judge had found, would eventually discover this 5 milligram dose was effective. So the second case on the slide, Phillips and Asus. Now, the point of interest which I want to draw out here is commercial attractiveness. What's the role of this in the common general knowledge, and how does it affect what the skilled person does? And here the Court of Appeal really continued with the same emphasis as in the Dyson and Hoover case, where Lord Justice Sedley referred to the Hoover market as bag-ridden, which is a terrific phrase. And what he meant by bag-ridden was that everyone was obsessed with bags. That's where they made all the money on these things. So the skilled person wasn't particularly interested in researching something which didn't have a bag, because that's where all the money was. And just as in that case here, the Court of Appeal affirmed that commercial value was something which might lead the skilled person in a certain direction, but an invention couldn't be inventive simply because the skilled person wouldn't appreciate its commercial appeal in advance. So it's an important distinction between those 2 points. Third case is Empson and Hoselock, fourth including the Supreme Court. 2 points of interest here. First, obviousness of prior use. So the inventor had been messing around with hose pipes in his front garden on lots of different days. And the court held that you can't treat all of those different events as a single prior use, put them all together, and then look at obviousness. They're all separate disclosures, and to put them together is essentially mosaicing. The second aspect on obviousness, which is interesting, is that this was a patent that had previously been found valid. It had a certificate of contested validity, and yet the same prior art, the second time round, invalidated the patent. So I know the JIPLP has a big interest in the international picture, where we're always striving for consistency between jurisdictions, but it's actually quite hard to even have consistency within jurisdictions. So for food for thought there. The next case was Garman Phillips. In this case, we saw the lesser spotted collocation, which is the collective noun for a group of inventions. And the law on this was set out by Lord Hoffman in the case of SABAF and MFI. And he said there's no substitute for the statutory test for obviousness. But before you ask yourself that question, is this invention obvious? You have to know whether you're looking at one invention or two inventions or more. And in this case, it was said that the patent related to a number of different inventions, which might all be implemented in the same device, a sort of fitness tracker. But the court disagreed. In Henry Carr's judgment, he said there was a synergistic effect between the fitness tracking element, the music playing element of the invention in the conditionally valid the conditional amendment which led to the valid claim. And the last bit on obviousness is there's a little bit in Regen and E-Star. And this saw 2 points. The first was a Schlumberger type point, which saw the skilled person being different for the purposes of inventive step as they were in sufficiency. And the second was a tentative restatement of the position that common general knowledge is territorial. That is that when you're looking at obviousness, the common general knowledge the skilled person brings to the question varies in the UK, from France, from America. But the judge wasn't quite sure about that, but he sort of tentatively decided it. That's a very fast run through obviousness, well, as fast as I can manage, which I believe brings us on to other flavors of obviousness with Trevor.
Thanks. Yes, and the next topic is what some people call aggriever obviousness, what the English courts have rather clunkily started to call lack of technical contribution obviousness, and really the overlap between that and claim breadth insufficiency, or what we otherwise call from an English point of view, biogen insufficiency. And I mean, if you look at the cases overall, it's really rather sort of confusing as to the courts don't undertake separate analyses of these where both are argued. They will determine the issue on one legal basis and then essentially say the other one follows. And the third case on the slide, the Takeda case, which Kit's already referred to, is a good example of that. The claims were held to be agreevo obvious, essentially, and there was no separate analysis of biogen type insufficiency. And I think we may be seeing in the English courts more of a recognition of the EPO approach of agreevo obviousness as a way of dealing with overbroad claims, and less emphasis on biogen going forward. I mean, a lot of biogen has been chipped away, not only, well, probably mainly by Lord Hoffman, who gave the judgment in the first place, but he then chipped away at it in the Lundbeck case. But the claim breadth insufficiency still has application, though, as one saw in the Eli Lilly and Genentech case, the first on the slide. But that's in the very special context of second medical use. There was no analysis of any agreevo type issue in that case, and generally there aren't in such cases. The TQ delta case is an example of this agreevo obviousness type argument, an attempt to run it outside its roots in chemical patents. And so the relationship between these is still being worked out. There is a throwaway line by Sir Richard Arnold in his judgment in the Acarbia case, which suggests that sometimes somebody's going to have to look at this. You can find some sort of guidance in the EPO case law, case G1 of 03, disclaimer PPG, discusses it in section 252. But it's an interesting topic going forward, and I think we are going to see less emphasis in the UK cases in future on biogen insufficiency, other than in the context of medical use claims, and more emphasis on lack of technical contribution obviousness. But with that, I'll hand over to Kit to talk about yet another type of insufficiency.
Thank you. Yep. The next kind of insufficiency we're going to talk about is uncertainty insufficiency or ambiguity. So really what this is about is can the skilled addressee of the patent really tell whether or not they are working the invention? Is it sufficiently clearly and unambiguously disclosed for them to do so? And the key case in this area is Cronan, which is in the House of Lords. And that was a case in which a claim was found to be insufficient on the basis of ambiguity. So the first two, well, the two cases that we're going to look at are the Annan Neochemicals case, and then we're going to go back to my favourite, Takeda and Roche. In the first case, relating to Neochemicals, the claim was for infringement of a patent that concerned a method for producing ceric oxide. This is a catalyst that is used for purifying vehicle exhaust gas. And the relevant term in the claim, it was that this product must consist essentially of ceric oxide. So one of the grounds of invalidity pleaded was this ambiguity insufficiency, because the meaning of it consisting essentially of ceric oxide is potentially ambiguous. So parties agreed what was meant by consisting essentially of ceric oxide, and that was that apart from the mandatory ingredient ceric oxide, there should be no other ingredients present which materially affect the essential characteristics of the product. So is that ambiguous? How would an infringer know whether they are within or outside the scope of a claim? according to NEO, if allegedly infringing ceric oxide contained an ingredient other than ceric oxide, then you'd have to perform a test to determine whether the presence of that extra ingredient had a material effect on the essential characteristics of the product. So that they called a materiality test. And then in order to do that test, what do you compare it with to see if it's materially changed the characteristics of the product? Do you need a pure sample of ceric oxide? You know, how do you actually perform this test? They argued that would be an undue burden on the skilled person. At first instance, these arguments failed and the patent was held valid and infringed. And then it went up to the Court of Appeal, where it came before Lord Justice Floyd. And Trevor's already done a spoiler, which is to tell us that the Court of Appeal upheld all first instance decisions. What Lord Justice Floyd said in this case was that asking whether an alleged infringer can find out or ascertain whether what they're doing is within or outside the scope of the claim is not the relevant question. What matters is that the claim is conceptually certain. And if it is, it's not going to be rendered insufficient because there's some doubt around where the edges of the claim are found, so-called a fuzzy boundary. So on the evidence that was before the court, NEO hadn't established that this testing would require an undue burden on the skilled person. Floyd accepted that the skilled person could perfectly well do this test and make a decision about whether there was the product's characteristics had been materially affected. So that claim for insufficiency was dismissed. So going back now briefly to Takeda and Roche, and again the claim integer that related to 99% fucosylation of the antibody. Takeda argued that the claim was insufficient on this ground because it wouldn't be clear whether an antibody fell within the scope of the claim, and that was because the claim didn't specify exactly how you should test the level of fucosylation. There existed two different peptide mapping machines that the skilled person could use for the analysis, and depending on which machine was used, the results either fell within or outside the scope of the claim. There's nothing in the claim or the patent to tell you which machine was supposed to be used. And relying heavily on expert evidence, the judge reached the conclusion that the claim was truly ambiguous and therefore invalid on this ground of ambiguity. So 1 for and 1 against there on uncertainty and insufficiency. So moving on now to Trevor, I think.
Yes, and I mean, as a comment on that last point, before I talk briefly about added matter, this type of insufficiency seems to be one that is becoming more important in the English courts. I think it was in the early days, it used to be very much regarded as an outlier, but we seem to be, it seems to be rearing its head rather more than it used to. So we'll have to see how that goes going forward. On added matter, there's 2 cases on the slide, the Conversant and Huawei case. An example of an English court finding a patent bad for added matter. That's important in that case because the patent had been found essential, not to be obvious, not to be insufficient. And so the only reason it was found invalid was for lack of added matter. But there was no dispute about the law in that case. There is never really any dispute about the law in added matter cases. It tends to be how the law is actually applied. And Novartis and Dr. Reddy's is a very interesting example of a difference of approach between the English courts, Colin Burse in this case, and the EPO. And in that, an application was made for an interim injunction in a pharmaceutical case in relation to a combination, a patent for a combination, second use, I think it was, for a combination. The patent had been found invalid for added matter by the EPO opposition division on its sort of selection from multiple lists criteria. And Colin Burse said, no. He analysed the thing thoroughly and looked at the specification as a whole, and what he said at paragraph 46 of his judgment. I disagree with the decision of the opposition division. Their decision appears to take an unduly technical approach, which has lost sight of the disclosure of the document as a whole, and has also lost sight of the prominence of one of the components of the claim combination in it. And so this does demonstrate perhaps a more general point about added matter. I think we're all conscious that certainly in EPO practice, there is, if you like, a sort of procedural bias towards finding the added matter, because that's the first thing that the tribunal will analyse. And if you die on added matter, then you don't get to hear any other arguments on anything else. But personally, I sometimes feel that perhaps one of the underlying differences between the EPO approach and perhaps the approach of the English courts is the approach of non-native English speakers to documents written in English. I think that non-native English speakers are rather stricter in the interpretation which they place on English words than perhaps native English speakers are. I think this may also be a feature as to why, despite all having the same law, we seem to come up with quite answers on added matter an awful lot of the time. I think with that, we've finished the substantive law, and we have 15 minutes to cover everything else. And Ed's going to kick off with procedure.
So I can see the participant numbers at the bottom of the Zoom, and I'm expecting every mention of jurisdiction case to lose us about 10 people, but I'll rattle through it as quickly as I can, but not so quickly that it ceases to make any sense whatsoever, hopefully. So the first case, I won't try and pronounce the claimant's names, I have no idea, so I'm just going to call them Company A. And Company A and VH Squared have been having a bit of a dispute about jurisdiction, because each of them has a license, one for the reserved sector and one for the rest, essentially. The issue is about the terms of the license, the head license for VH Squared give exclusive jurisdiction to the Belgian courts. Meanwhile, there are UK designated patents. So you can see there are going to be potential conflicts between two exclusive jurisdiction provisions. Now, what the Court of Appeal did really well in their judgment is to pull apart the substantive and procedural aspects of dealing with the Brussels recast. So the substantive law part is that Article 24 gives you exclusive jurisdiction over a UK designation of a patent. Article 25 gives exclusive jurisdiction in relation to choice of court. But Article 25(4) says that if you try and choose a court, but in doing so, essentially try and overrule the Article 24, then that agreement is void. So that was the substantive dispute between the parties. But there was also a procedural dispute about the turns, essentially, that the UK and Belgian courts should take in deciding who was actually going to deal with the issues, which can actually be just as important as the substantive dispute when you're trying to get a case into court. So the way it was dealt with in the UK was to look at the principal subject matter of the claim in the UK, which was a claim for infringement of the patent. Validity hadn't yet been put in issue. And what the court said in that respect was it wasn't possible to say the principal subject matter dispute was the validity of a UK patent. There were other possible defences. And this meant that it wasn't possible to say that the Belgian court was going to have to hand the dispute over to the UK. And sorry, I've kind of got my two legs the wrong way around. That was sort of the second leg of the court's analysis. The first was that it wasn't possible to say that the jurisdiction clause in the head license wasn't effective at a summaries level, and therefore the UK court had to hand the dispute to Belgium to see whether or not that contract was going to bind Company A, the claimant. So ultimately the dispute has now stayed in the UK courts while Belgium decides exactly what happens. The second case is QuickBolt. So this is a company with turnover less than around £630,000, suing Airbus with revenues of over £50 billion. So Airbus's argument, core of it, was that it might lose sales worth hundreds of millions if it lost. It's a very serious claim, should be dealt with in the patents court. But HHA Haycon took the IPEC's usual robust view on transfer and said that this would only be relevant if Airbus could establish that it was somehow going to be treated unfairly by a trial in the IPEC. And the judge said that this just wasn't the case, that they'd get a fair hearing in the IPEC, the patent wasn't unduly complex, trial length wasn't an issue, and this was exactly the kind of thing the IPEC was suitable for, given the imbalance in resources between the parties. I would note that there have been some cases that escaped the IPEC recently, and just sheer complexity seems to be the main factor. Whether this is warranted complexity or not, it does seem to help you get out. So the next case is Coloplast, a judgment by David Stone, of Allen and Overy, sitting as a Deputy High Court judge. So as we know, the default position is in favour of a stay, pending the EPO opposition. But in practice, that's just not what happens, it seems. This seems to be mainly a result of the factors that the court has to take into account. And in particular, the one that's always going to come into play is the length of time before the opposition is going to be resolved. And almost always, there are also going to be issues of infringement between the parties. And those were the two main factors here. The court said that we're just not going to wait for the EPO to deal with this before we sort out the issues between these parties in the UK. And I think the same outcome would be common in many cases. The next, we have Anand Kasai again. In this context, to do with joint tortfeasance. Some people are surprised that it's possible to add another party as a joint tortfeasor following judgment, but it doesn't offend against the Aldi principle of bringing your whole case at once. In this instance, to simplify the facts, Neo UK came to be owned indirectly by Neo Canada, and the claimant sought to join Neo Canada as a joint tortfeasor because they were worried Neo UK weren't going to be able to pay up. And so the key question is that which was put forward by Lord Justice Chadwick in MCA and Charlie Records. And that is, did the acts of the parent company go beyond constitutional control? And the Court of Appeal held that the judge at first instance had got it slightly wrong, and that he'd maybe been a bit hard on the evidence that was available. Because the question is this a triable issue? This is a summary stage. And therefore, the Court of Appeal said it wasn't surprising that an argument that that this had gone beyond constitutional control couldn't be fully made out on the information available, because we hadn't even had disclosure yet. And so ultimately, the Court of Appeal allowed the issue to go ahead, and I imagine that will go to trial in combination with the hearing on quantum. The final two cases both relate to attempts to reopen trial or to add new evidence following trial. The Liquid case is one of the first appeal judgments of Lord Justice Arnold. In this case, L'Oréal sought to adduce further expert evidence and experimental evidence following trial to support its anticipatory citation under Section 2.3 of the Patents Act. So the original case L'Oréal ran at trial was that an example in the prior art was entitled to an earlier priority date because the chemical in the priority document would hydrolyze into the chemical disclosed in the prior art document. However, at trial, L'Oréal ran a new case through the cross-examination of Olaplex's expert. And this new case was that the synthesis directions in the priority document didn't produce the chemical in the priority document. They produced the chemical that was in the later one. And the actual chemical disclosed in the priority document was a mistake. And so they produced experimental evidence of what happened with the synthesis in an effort to essentially reopen the issue. And Justice Burse said, no, I'm not accepting this evidence at this stage, and even if I did, I don't think it would be determinative. And a couple of factors came into his reasoning about not letting it in particular under the overriding objective. He said that the point should have been notified to Olaplex before their expert got in the witness box, and that there was even a late filed expert report by WilmerHale during trial. And it seems that even some hint of the point could have been canvassed at that stage. So judgment was handed down. WilmerHale sought to reopen the judgment under the court's jurisdiction following on from the 2013 Supreme Court judgment in the matter of L. And the Court of Appeal, to cut the story short, dismissed the application as well, saying that the judge's decision had a fair level of regard for the value of the time and cost to parties and the court. Regard had to be had to WilmerHale's attempt to have the point dealt with at trial without requesting an adjournment, and that they'd essentially lost the way they'd initially run it and come back for a second go. And they held that wasn't a good basis on which to allow in this late filed evidence. In Regent, vaguely similar actually, here the application came before judgment. This time an alleged prior use was essentially found in someone's bedroom closet. The argument arose as to whether the point could have been pleaded before trial, and this sort of split down two lines based on the arguments of prior use. One side of the prior use is how this should have been pleaded before trial. If the correct inquiries had been made, this would have been discovered. The second line, they said, well, actually, there was a new line of argument which couldn't previously have been pleaded. But the judge said, this is all a moot point. You came to do this before I handed down my judgment. In that respect, perhaps preferably to Liquid and WilmerHale, but actually I've decided the patent's invalid anyway. So I'm not going to deal with this now. However, if the Court of Appeal decide I'm wrong on validity, then perhaps this could be an issue dealt with if the case were to be remitted to the High Court. So I think the key principle is that say what you know as soon as you know it. And if you have to adjourn, you're going to have to adjourn, and you can't sort of try and ride two horses. So I think that's up for Kit on remedies next.
Okay, very good. So this is slide 12. I'm going to go really quickly because there's some juicy stuff coming up. And actually, there's not a lot of magic in the remedies decisions here. We've got 3 decisions on interim injunctions, one granted, one not granted, and one that's slightly different sort of application. Very briefly, in Novartis and Dr. Reddy's, here we have a sort of classic case of a patentee with a second medical use patent, a generic who obtained authorization under a full label, which was a rather punchy decision, and the application for an interim injunction to prevent generic launch. Mr. Justice Burst was presented with all the usual factual evidence that comes out in pharmaceutical cases like this, which demonstrate inevitable price erosion, loss of market share, and so on. These are very familiar in these sorts of cases. And he found quite straightforwardly that there was a real risk of unquantifiable loss to both sides, whether the injunction was granted or refused. It followed that he found it quite easy to grant the interim injunction, maintaining the status quo and preventing generic launch. In eValve, this is a medical device case, and very similar in a way. Lots of evidence was put before Mr. Justice Henry Carr regarding financial and commercial losses in order to seek to establish unquantifiable loss. But when weighing the harm to each party, the judge found that the greater harm would be suffered by Edwards if the injunction was granted, and therefore in this case the injunction application was refused. So we got one granted, one refused, and it's sort of continuing that line of case law that in pharmaceutical originator versus generic, it looks like the chances of getting a PI are pretty good. In NAP and Dr. Reddy's, we have a situation where an interim injunction had been obtained by NAP against Sandoz. At a preliminary stage, the case had gone to trial, then been upheld at appeal, and the injunction was discharged. The question concerned the undertaking, the cross undertaking in damages. it was Dr. Reddy's were concerned that NAP's financial position was had changed, so that there was a risk that they may not be able to substantiate and pay the claim for any damages awarded against them, and therefore sought fortification of the cross undertaking. Mr. Justice Henry Carr held that the court had no jurisdiction to grant fortification of a cross undertaking in damages where the injunction has already been discharged, and even if they could do so, the evidence on NAP's financial position wasn't sufficiently strong to justify fortification. Moving on to arrow declarations. Here we have a case which on the face of it looks very similar to the key case in this area, which is FKB and AbbVie. We have a situation where Pfizer sought an arrow declaration to obtain commercial certainty for launch of its biosimilar bevacizumab antibody in the face of a so-called patent thicket held by Roche. These were lots of secondary patents and patent applications that related to various combinations of bevacizumab with other known cancer drugs and used in various different cancer indications. Pfizer wanted to prevent the risk of a PI, and we can see from the earlier analysis that, fair dues, there's quite a high risk of a PI if you launch that risk, and so sought an arrow declaration. Roche responded as AbbVie did on initiation of the proceedings by withdrawing the UK designations of their existing patents and patent applications. So at the time this came to be heard, there were no live rights in the UK. What was different from the situation in AbbVie was that there was no possibility of any rights coming to light in the UK at all, whereas in AbbVie what we had was a situation where there was a very strangely worded undertaking which created a lack of certainty. Here there was no such lack of certainty, and so the judge had to decide whether the declaration would serve a useful purpose, where the only real reason for obtaining the declaration would be its spin-off value in potential proceedings in Belgium, Belgium being part of the supply chain for this product in the UK. There is case law, it is, the name escapes me at the moment, to the effect that that the dispute, that spin-off value can be a reason to grant a declaration, but it has to be considered very carefully, because we don't want to be in a situation where forum shopping is taking place. And Burse decided that in this case, if the matter ever did come before the Belgian courts, it would be about a Belgian patent under Belgian patent law, and the UK court would be in a better position to rule on that than the Belgian court. And therefore, given the only value of this declaration was its spin-off value, the declaration shouldn't be granted.
Sorry, just to fill in, I think the case that you were thinking about was Deutsche Bank.
It is Deutsche Bank. You are right. Thank you, Stefano. Yes, that case was one where there was a UK right, and therefore the UK courts were actually better placed to make a decision than having that go ahead in a foreign court. So that was how that Deutsche Bank was distinguished. The last case on this slide is Price and Flitcraft. This was a patent and copyright infringement case. And the take-home message from this is that if you're injuncted, take it seriously, and if you don't, you could be found in contempt of court. And that's what happened here, when the defendants they really didn't care that they'd been injuncted and carried on doing as they pleased. So I'm going to stop there on remedies and I think hand back to Ed.
So the first case on this slide is the Shanks and Unilever judgment by the Supreme Court, which was the end of a 13-year journey by Professor Shanks to receive some of the outstanding benefit which his invention had proved to Unilever. And the argument that had really been put forward by his legal team had been that Unilever is a huge company. If you check the outstanding benefit by reference to the size of Unilever, then essentially the defendant's arguments amount to too big to pay. which is this terrifically catchy sort of soundbite. And the Supreme Court overturned the sort of verdict from the 3 prior tribunals and decided that actually Professor Shanks's invention had been of outstanding benefit. And in doing so, I think they were clearly concerned about sort of an opening the floodgates type position, and did insist that, you know, this is a very sort of fact-specific matter. And some of the information that they took into account is very specific to this scenario. For example, you know, the amount of money that the invention generated was one factor, but, you know, Unilever had made that money without actually having to make particular efforts to commercialize the invention. A number of the licensees had approached Unilever to take a license, for example. And so while this is really a big deal for the Section 40 of the Patents Act, I will be surprised if we see a lot of successful follow-on claims in this area. But I think it'll be interesting to see how the lower courts interpret the judgment. The second of this case is BDI. The reason this is of interest, it's sort of fairly regular entitlement dispute, but because the inventive concept rears its head. Because of course in Yeda, which is the House of Lords case on patent entitlement, where I believe Trevor represented one of the parties, Yeda looked at the inventive concept and said the inventive concept was a relationship of discontinuity between the claimed invention and the prior art. His Honour Judge Haycon looked at sort of that definition, and he looked at the definition of Actavis, you know, the inventive core, and he looked at Pozzoli, and he said, you know, there it's referred to as a précis with, you know, unnecessary verbiage stripped out. And he looked at all these different ways of looking at the inventive concept. And then the question arose, you know, what's the difference between these ways of looking at the inventive concept? And the judge's answer to this question was to say, quite tantalizingly, if the meaning given to inventive concept differs at all between Yeda, Actavis, and Pozzoli, it is not by much, which I think is terrific, and has not quite resolved my my concern about the inventive concept as a useful part of patent. That's all I have to say on that. So I'll hand back to Trevor, who's going to give us a guide through SPCs.
Yeah, given time, a very quick guide indeed. Although, just commenting on Ed's point, we see more and more, of course, of the inventive concept, because it is now part of the first of the improver questions applied in the context of determining whether or not there's equivalence. So I'm afraid we haven't got rid of inventive concept, whatever it means. Anyway, briefly on supplementary protection certificates, because I think most of what I wanted to say is actually on the slide. And not too much really happened in 2019. Probably quite a lot is going to happen in 2020. The important case in 2019, I think, was the UK Court of Appeal trying to make sense of the Court of Justice decision in the Trevor case on the vexed question of what is meant by protect in the context of the supplementary protection certificate regime. And that was in the context of a combination product. And that was a very sort of thorough, well-reasoned and helpful decision. More recently, we've seen the Court of Justice just the other week in the Royalty Pharma case bring on a whole new world of pain as to what is meant by protects. But that is not in a combination product context. That is in the context of a single product. And whether something is actually protected by a Marcouche claim, or whether you have to go into all sorts of inventive step type analyses. And who knows, perhaps the English court will make sense of that. The other Court of Justice decisions, the Abraxas case is really going to be which is on this old urine case about can you get a new SPC on a new use for an old product. That is going to be supplanted when the Court of Justice decides the Santen case. So we wait on that. And the attempt by the English courts to get the Court of Justice to focus on the whole question of SPC spotting and third-party SPCs in the Lilly and Genentech case failed because the action failed for other reasons, and so the Court of Justice held the reference to be inadmissible. That is all I'm going to say about SPCs, and I shall then hand on to Ed to talk about standards essential patents and FRAND.
So I'm going to try and keep this brief. I may or may not be successful. First of all, the TQ Delta Zeisel High Court case, there's one point of interest there, which I like, which is Sir Henry Carr's, late Sir Henry Carr's comments about the skilled person's approach to standards documents. In particular, there was a bit of debate in that case about essentially how big a standards document can get. And the answer is, well, it can get as big as you like. The skilled person still reads it. They are still that massive reading machine, but they may not be interested in all of it. And in this case, it didn't sort of come down to much, but it's worth keeping in mind when putting together prior art attacks that potentially rely on multiple parts of a standards document. The skilled person is really going to be concerned with the bits that relate to their specific expertise. Huawei and Converse, I'm actually going to skip that one in the interest of time. The Philips and HTC Court of Appeal hearing, it's interesting here to see the Court of Appeal had a teach-in, which is a terrific resource, something that the UK courts can do. There's not that many jurisdictions that will do that kind of thing on appeal, so I think that's a very valuable thing to keep in mind. Next, this is sort of the meat of what happened in 2019 in terms of FRAND. This is the Zeisel waiver. What Zeisel did was a bit like what the chap did in that film, 127 Hours, where his sort of hands sort of stuck under a boulder. Zeisel was very unhappy about sort of meeting the cost of this FRAND trial and the UK court's newfound ability to set the terms for global license, and it took the commercial decision to leave the UK market and essentially waive its right to a FRAND license. And so the immediate question that arose is this a decision that's open to many implementers? And it requires the company to be willing to be injuncted from the UK market for the duration of the infringed patent's life. In Zeisel's case, the remaining time on the patent wasn't huge. The UK market was a relatively small part of their business, and the commercial decision took them down that route. That's not necessarily going to be true for many businesses, and in fact, we've seen already that ASUS have tried something similar unsuccessfully in their case against Philips, which saw a judgment handed down earlier this year. The one interesting part about sort of the sort of TQ Delta Zeisel bit was Justice Burse at the first instance said, we need to go on with the FRAND trial anyway, and as a sort of declaratory business, and the Court of Appeal disagreed. And were quite critical, saying that Justice Burse observed cryptically that the waiver is arguably just more holdout, but he did not explain how this observation led to the conclusion that there was still some proper basis for useful declaratory relief. And sort of Justice Burse, I feel quite sorry for him, because we really want to see him do another FRAND trial, to see him set another FRAND rate. And I think actually it would be in everyone's interests for him to have that opportunity. But it just hasn't happened yet. So I sort of feel sorry for him getting that bit of criticism for the Court of Appeal there. I'm actually going to skip Optus and Apple in the interest of time as well. I'm going to say a few words quickly about Vestel and HEVC Advance. This is interesting because it's the opposite way around from what we expect. We're seeing an implementer come to the UK court trying to get a FRAND license. And so Vestel's a TV manufacturer, and the license they wanted was from a patent pool called HEVC Advance, and the other defendant is Philips. And this is a bit of an oddity because HEVC Advance is a patent pool in the area of high efficiency video coding. It is not the only patent pool. There's another patent pool called MPEG-LA, and conveniently the patents in the two pools overlap, but not completely. So Vestel had a license to this one pool, and it wanted a license to the sort of sliver of patents that were not in the pool it had already licensed. and it said that the terms it was getting from HEVC Advance and Philips weren't FRAND, and it came to the UK courts to try and get them to settle the terms of a FRAND license, and it did so on the basis that the activities of HEVC Advance and Philips constituted an abuse of a dominant position. And this created a different jurisdictional position than we usually see at the beginning of FRAND cases. So the assessment came under principally in respect of Philips, which is obviously domiciled in the EU, under Article 7.2 of the Brussels regulation, which is, we're looking at where the harmful event occurred. And Vestel were unable to persuade the judge that Article 7.2 of the Brussels reg applied, because Philips might never enforce its patents in the UK, and even if it did, the rate would be FRAND, and therefore there wouldn't be any damage in the jurisdiction in respect of Article 102. So then the judge moved on to look at HEVC Advance, which is domiciled in the US, I understand. So you have to look at the jurisdictional gateways for service out to see whether service out had been conducted properly, or sorry, was permissible. And the judge looked at gateway 11, which relates to property in the jurisdiction, and in relation to a patents case, that's what would happen. But only 4.9% of the patents in the pool were UK patents. And the judge, which is Honourable Judge Haycon, sitting in the High Court, said that service out under this gateway wasn't a goer. And there's sort of a real difference there between the approach in the patent-led cases and in this case, which goes to show that even the procedural aspects vary hugely depending on the basis for a FRAND case. So I think implementers in this situation have to ask, what's the solution here? How do we get the UK court to set a rate? And the approach is probably to do something similar to what happens in the patents side, which is to set an anchor defendant, i.e. find a patent owner in the jurisdiction, or alternatively to bring some claim which relates to the patents. Don't just do it as an Article 102 approach. So that could be either challenge the validity or a statutory declaration of non-infringement under Section 71, and then you can use some of the provisions for related actions or parties that should be added to a claim to try and bring the whole FRAND dispute into the UK. And I expect we might see more of that in the near future. So I think that's it for me on FRAND. And I believe Trevor wants to talk about some coming attractions.
Yes, and this is thank you very much to those of you, I think there were 69 of you, 68, who've stuck with us in our extra time. This is the last slide, and subject to anything Stefano has to say. Last you'll be hearing from me. Two coming attractions in particular, again on SEPs and FRAND. The Unwired Planet, Huawei, and parallel Huawei and ZTE in conversant actions, which were held, hearing of which took place in October 2019. Leave was given earlier in 2019, in the spring of 2019, proceeded on an expedited basis, but we still await judgment, and everybody is holding their breath as to what that judgment might be. There have been indications that certain of the parties in those proceedings may have settled, but that would not of itself preclude the Supreme Court giving a decision on this fundamental question of whether or not it is appropriate to require an implementer to take a global FRAND license as a condition of avoiding a UK injunction. So we await that with bated breath. The other one we await from the Supreme Court, when there was a hearing just earlier this year, is Regeneron and Kymab, and that was where the Court of Appeal, another one of Kit's favourite antibody cases, reversed the decision of Henry Carr at first instance, who found the patent, the claims to be insufficient. They found them to be sufficient. And so the Supreme Court is going to review the law of sufficiency, but not with the sort of gloss of plausibility or the gloss of second medical claim issue that it had to deal with in the Warner-Lambert case. So this should be a sort of pure claim breadth insufficiency and wider insufficiency analysis. And it'll be very interesting to see whether it leaves things rather as the Court of Appeal have done, or whether it actually makes some fundamental change to the law there. But that's everything I have to say. Thank you for sticking with us.
Thank you so much, Trevor, Kip, and Ed. I think this was absolutely brilliant. And yeah, as we said at the beginning, even if no big changes have taken place, there's a lot of details that, there's a lot of that is happening under the surface, and probably in the coming years, we will see those bigger changes that come from incremental, essentially looks into important aspects of patent law. So thank you so much to everyone. Thank you so much also to the 65 of you who survived for an hour and 20 minutes. And, the invitation for everyone still stands. Yes, Trevor has taken the lead in writing a fantastic patent roundup, and Ed has written also for JIPLP. And anyone that is interested in these issues, there's a lot, I think, that a community can learn from just discussing all of these different aspects and all of the fine details that have been also discussed today. So for anyone that wants to put pen to paper, I think is the English expression, there's a lot that patent law has to offer. And thank you so much, Trevor, Kip, and Ed, for this fantastic webinar. And I hope that you all enjoyed this. Thank you.
Thank you very much for organising, Stefano. It's very kind of you.
Thank you.
That was a pleasure. Thank you very much.
Bye.
Goodbye. Bye-bye.
Cheers all.
Bye.